Good evening. Welcome to PoliticIt podcast. Tonight we have Rob Bishop with us, former congressman, former Speaker of the House, even in Utah. Nice to have you.
It's good to be here. Thank you for the invitation.
Yeah. Well, last time you were here, we talked about your book. I'm going to just hold this up again. Things I learned in Congress, they never taught in school.
And I appreciate that, but you see, I was a school teacher, and I realized the textbooks, they weren't purposely wrong. By the time it takes a textbook to be approved and going through the process, everything's changed.
Yeah.
So the textbooks I was throwing at the kids, they were inaccurate. So I felt compelled when I was back there to write the experiences I was having, the stories I wished I could have used when I was actually teaching the subject, and it's all down there. So if you really want to know how Congress is organized and functions, with some stories of what it was like living in Washington, that's the book.
Yeah. Well, I mean, that personal experience, it's kind of a, you like to kind of relate what you did for all those years, huh?
And part of it was also because I had spent 8 terms in the Utah legislature and then went away from politics before I ran for Congress. So the comparison to what you do in the Utah legislature versus what we do in Congress is like night and day. The Utah legislature has very specific rules. Like, for example, everyone is in committees at the same time and you're on the floor at the same time. There is a flow to the debate. In Washington, because we have a process called rolled votes in the name of efficiency, no one's ever there to hear any of the debates. They come and vote, but they're voting in basically ignorance with control by the leadership just because they're not there for, and it didn't used to be that way. It used to be people would actually go into the House of Representatives. The Senate used to adjourn to go into the House of Representatives to listen to the debates. There were congressmen in these early years who would say they would go there, they would listen to the debate, it would change their mind on how they voted. So it's one of the things that is so good in the Utah system, of where there actually is a debate that has a flow to it and an understanding that is just totally lacking in Washington, and it's sad.
It's interesting in the Utah legislature. Both bodies caucus, right? Mm-hmm. So you have massive debates in caucus. It seems like the caucus in the Senate works pretty well. I don't even know if it works that well in the House. I don't know if that's always the case, but
it does. It's called a conference back there. And at least we don't go through the charade that it's supposed to be secret. Everyone knows what's going to be said in the conference. One time when Hastert was the speaker, he'd given a proposal and he told them why they wanted them to do it. And one of the members said, "Why don't you go out there and tell the media that?" And he said, "I just said it in conference. I thought I had."
So that's kind of what happened.
The idea of a closed caucus is actually an oxymoron.
Yeah.
It doesn't really happen. But,
it actually works pretty well in the Senate, but only in certain areas, right?
It gives you a chance in Utah, once again, which is why I like the Utah system. It gives you a chance to talk about things and then have to go out there and then stand up and give an open statement and a vote for which you would be accountable. Just one time when I was a younger legislator, and Norm Bangerter was speaker, and he was proposing something, and everyone was whining about, what will the media think about it? What will our voters think about it? And finally he got tired of it and said, just go out there and do what's right, and everything else will take care of itself. And if they don't like us and kick us out of office, I'll feel bad next January about halfway to St. George. So that is really the kind of attitudinal voting that does take place in the House and in the Senate. But at least in the House and the Senate, you have a place in which they can be discussed, both on the floor as well as in the caucuses.
Yeah, and you kind of know where people are. And the nice thing is you get a chance to know whether an argument that you're making even resonates with anybody.
Yeah.
Right? And so, you don't see as much in the Senate of people. I mean, we have a few people that like to throw everyone under the bus when they get on the Senate floor, right? But that doesn't usually happen. If you know your statement's going to fall flat, you vote against it, and you just chalk that up to.
Yeah. Throwing somebody under usually happens once, but doesn't happen the second time.
Well, we have one guy that likes to do it every time, but
But you have a lot of people thinking in those caucuses that that's where the smoke-filled rooms are and arm twisting takes place. It doesn't happen. When I was Speaker of the House, we never had a party line vote. I never asked anyone to do a party line vote. I once asked them, I want to know how you're going to vote, because this is going to take 2/3, and if it's not going to pass, I don't want to spend a lot of time on it.
Yeah.
But I never tried to twist anyone's arms, because I realized Utah is a pretty conservative state. The members in the legislature will be fairly conservative, except for a couple of areas.
Yeah.
Very conservative, and the end result will be good at the end of the day. Yeah. And I can count on that to take place. And that's something that's really good about where you were serving in the Utah legislature.
Yeah. Yeah, I like that part of the job. I really like the discussions we have, especially in caucus, where we can be pretty frank. You know, I feel like I can say things that I would never say on the floor, simply because I don't like to embarrass people in public, right?
That's good.
But you can be brutally honest about how you feel. And you know, as far as the arm twisting, I've never felt like people twisted my arm.
People have a negative view of the legislature. We make jokes about ourselves in the legislature all the time. But that does not actually equate to what the legislature does. And truly, a legislature is the chance where every part of the state is represented, and everyone does have a chance of actually having a say of what takes place. And the legislative process is something that should be venerated by most people, not criticized and degraded, because it actually it's an ennobling process. And what you do in the Utah legislature is far better than what we do in Washington. That's chapter 6 and 7 about,
Oh, really?
About where we're doing it wrong in Washington.
You know, one of the things I really wanted to ask you about, and this goes back to the legislature, because we've just had this Amendment D, right, that just was thrown out by the courts. But what the Supreme Court did really bothered me a lot. And I don't know if you have strong opinions about that, or, you know, having been the speaker, you kind of understand what's going on. I mean, we've got this boundary case. It's pretty clear to me in the Constitution of the state of Utah that the legislature is responsible for drawing boundaries.
I have I rant on this a lot, especially at night when I'm trying to go to sleep, because I think the courts got it wrong. In the U.S. Constitution, it says that legislative power is invested. Legislative power here and granted, so Congress can't do anything it wants to, is invested in the Congress. So if a presidential executive order or a judicial decision on the national level have the force of law, that's subconstitutional. There's a problem with that. Utah's Constitution is a little bit different. Written in the progressive era, they have legislative power is in two places. One is within the legislature, and one is within the initiative and referendum process of the people. But if you think about it, what they were doing back then is trying to have some kind of balance. So an initiative or referendum could be there to balance what a legislature does, if you want to do that. But the legislature should also be there to balance excesses that would come through from an initiative or a referendum process. And that has what's been happening through 120 years of state, is the legislature always had that ability to balance off the initiative process. What the Supreme Court did in Utah is simply saying all of a sudden the initiative process can be sacrosanct under certain conditions as determined by the courts. And the legislature cannot balance it off unless there's a compelling state interest, which will be determined by the courts. What I think the Utah Supreme Court did is give an enormous growth of power to themselves that has never been there before, and is frightening to me, because it's not the courts that come up with the legislative power according to the Utah Constitution. It's the legislature balanced off by the initiative. But if the legislature doesn't have the ability to amend initiatives, you're skewed over in the balance.
Well, it's like now all of a sudden you've got this super law that is almost like a constitutional amendment, but it's not really.
Yes.
Right? And so what was not confusing at all in terms of the legislature's power over boundaries right? The legislative districts and boundaries. That was pretty clear. Now it's pretty fuzzy.
Yes, and it is very clear as well that the courts have given themselves, because the courts did say you can't, that an initiative, if it's dealing with governmental reform, is almost sacrosanct. But who determines that? The judge, yeah. And they say, okay, the legislature can amend it if it's a compelling state interest. Who determines if it's a compelling state interest? A judge. You've shifted the power away from the legislature, which is the voice of the people, and the people's process of initiative, and put it in the court system. And that's something that's unfair. You mentioned the Boundary Commission that started this entire debate.
You were part of that.
Unfortunately, yes. And the problem is, I can understand why the legislature made the amendments they did to, because they were the right thing to do at the time. And also, it's understanding that there needs to be some kind of balance of power. So the initiative that passed, barely, passed by 7,000 votes statewide, but it lost in 24 out of 29 counties. The reason it passed by 7,000 votes is because in Salt Lake County, it passed by 64,000, and in Summit, it passed by 11,000. That's a 75,000 majority, and when the rest of the state voted, it went down to 7. That says that the rest of the state was saying something different than Salt Lake County. The issue that I fear about initiatives, if you give them that super majority power, that super legislative status that the courts did, is you're actually allowing Salt Lake County to vote whatever Salt Lake County wants, and regardless of what the rest do. If the legislature has their say to balance it out, I have representatives, or you have representatives in the state that represent every major portion of the state. They represent everyone. Everyone has a say in there. And you don't get some one county becoming the focal point of all the power. When you did the Boundary Commission, the two problems I had with the Boundary Commission, and I was on it until I couldn't take it anymore and resigned, is number one, there was no accountability. As soon as the Boundary Commission made their statements, we went back into the woodwork of our deserved anonymity. The legislature, if you make those boundaries, has to stand up in public and vote, and then explain yourself to the citizens and stand for election. Commissions don't do that.
Right.
The second is we had no knowledge. We did not represent the state. In an effort to make a partisan process less partisan, we came up with a much more partisan commission of 3 Democrats, all from Salt Lake, 3 Republicans, all from northern Utah, 1 chairman, and the rest of the state, the south, the central parts, the east state, they had no representation whatsoever. And we didn't know what we were talking about. We knew our areas kind of, but when we tried to divide up Washington County, we were just throwing darts in the air. We're just making things up off the fly. We had no basic.
Whereas in the legislature, we have representatives in
who know their area and know what they're talking about and can say that won't fly. If that's the district, then you have to walk over a mountain to get to it. It's just impractical. So I see the problems that come with that. I also see why the legislature needs to be there to balance initiatives, which by the very nature of being a direct democracy approach can take someone's property or rights away by a majority vote, and that's wrong. The founders would have never, in fact, they didn't. That opportunity,
that's like two
turning over in the grave. Yeah,
that's like 2 wolves and a sheep voting over what's for dinner, right?
Right. That's exactly right. And there needs to be a balance. I think Amendment D was an effort to get the balance. I think the legislature hopefully will go back again. They will rework it, rewrite it, but to bring that balance back is essential. And the courts should not try to take that as responsibility upon themselves. Leave it on the people's voice in the legislative body, which is what the Utah Constitution wrote.
Yeah, it's just amazing to me. But you know, as I was thinking about that after the fact, the PR part of that, they had a lot easier explanation. They simply said, oh, this amendment is all about taking power away from the people. Right? Which is funny coming from the people that were making that statement. Right.
That's right. The people that were pushing that initiative had a very partisan purpose in mind. and they were funded, ironically, well, $2.1 million was spent to pass the initiative. $1.7 million came from one guy in Texas. $200,000 of it came from Utah. So there were some special interest groups behind it. And that's one of the fears that Utahns should have about putting too much power into the initiative process, which is once again why we talk about we don't want to turn into California.
Right.
California doesn't have any kind of balancing system in their constitution. They can't balance. We can. If that balance is taken away, we allow special interest groups to be able to fund an initiative, to fund a vote that's up and down without any kind of compromise and without any ability of giving some kind of balance to the system. If people want their rights protected, I'll give you one of the things which, well, to me it's significant, and to my county it's significant. Let's say that Salt Lake County wants to fill up the Great Salt Lake. And so they start an initiative to take all the water rights from Box Elder County, where I live, and put it in the Great Salt Lake. And you can claim that that is a reform of government because the Great Salt Lake is owned by the state. All water is actually owned by the state. So you could do that, and you could pass that initiative to take the water rights away from my constituents and my neighbors by a simple majority vote in Salt Lake County. And that's scary if there is not some process to balance it out so you cannot be that blatant. Now, such an initiative may never happen, but it could. And if the courts have given extra authority to the initiative and taken it away from the legislature to balance it out, the system is out of balance, and people's rights and properties could be harmed in the process.
Well, you think about this whole tie to the better boundaries idea, right? If you could go in to every red state and simply get one more congressional seat because of your better boundaries, right? That could change the balance of power in the country.
It could. And there are some people that are urging that as a course of action, to use the initiative process to get things. Let's face it, Utah is a very conservative state. The legislature will be conservative because they reflect the state of Utah. There are some people that don't like that and are saying, okay, let's use the initiative process where we can get supermajorities in one or two counties that will outbalance the rest of the state of Utah. They're using that as a process to try and change the approach so the state becomes less conservative, less concerned about individual rights, less concerned about the balance of power, which is, I think, essential. When I still teach school, and I'm teaching it right now in college, I tell people that my favorite...
You're teaching at Utah State, right?
Yes. I am. I'm in class. I don't know if the students there think I'm teaching, but I do tell them that my favorite founding father was Isaac Newton, who died a half century before anyone was even talking about a revolution. He never came over here. He wasn't a political scientist at all. He's a physicist. But it was Isaac Newton that came up with the idea that for every action, there's an equal and opposite reaction. And the founders of our system realized you can't write a law that makes everyone be nice. Madison called those parchment barriers, easily made and easily broken. But if you organize the system so there is a balance of power, no one person or cabal can get too powerful to make sure that so that they can take away the individual rights of citizens. That's why this country was Newtonian from the very foundation. That's why the system in Utah, which had initiative powers and legislative powers, they need to have a balance. It is essential. The courts took away that balance and threw it on the side of the initiatives over the legislature, and that's what could be dangerous. That's just simply misunderstanding the purpose of government and the role of government. And they just made a terrible mistake.
Well, and as you said before, it actually has shifted power, not necessarily to initiatives or the legislature, but to the court.
Yes, the judicial branch has taken power away from the legislative branch, which is supposed to be the voice of the people. And in the long run, that is not good for the state of Utah. And when people say, you're going to turn us into California if you keep going down this path, that will happen.
Well, we're going to take a break, and we'll be right back.
Okay. Hi, I'm Rob Bishop. Before I went to Congress, I spent 28 years teaching public schools, a lot of it in history and government classes. But when I got back to Washington, I realized the textbooks I'd been using in high school, they weren't really accurate of what the reality was. So I felt compelled in the 18 years I was back there to write down the experiences I had and try and explain what Congress really was like. And we published it in this book about the lessons I learned in Congress that they didn't teach me in high school. So it's about the philosophy of government, the importance of balance, but also in there of how Congress is organized, how they function, some of the weird things that they do, and then a few personal examples and stories of what it's like living in Washington, D.C. I hope it's enjoyable to people. I tell people I didn't have a ghostwriter, so I did it all myself. So if you have insomnia, this should be perfect for you. But if you want to know what Congress is really like, pick up the book.
Welcome back to PoliticIt. We've got Rob Bishop here, and I loved our discussion because I think this is a really an important issue. This idea of kind of this imbalance that's being created by the court, right? So, while we were on break, you talked about a case.
Let me add, it's an idea that I don't think's been in the public discussion yet. The public discussion, I think, has gone in a different direction that's missed the important point. And that's the important point of the balance you have between the legislative and judicial branches.
Yeah. So you brought up an interesting point when we were talking offline, and that was this idea that for people from outside the state can actually weigh in on Utah law and change things that affect Utah companies, right? Mm-hmm. And so let's talk about that just a little bit, about how that.
Well, there was 1 year, shortly after I had been elected to Congress, there was an initiative that was run in Utah that was designed by a company in another state, and it was Texas, to attack a company in Utah to make difficulties for the company in Utah to be competitive, which would mean they would have a lesser share of business, and that business share would then go to the company in Texas. And they labeled it as helping education funding take place, when it was really fighting for a market share. Fortunately, Utahns didn't buy it, and they voted it down. But it does present a precedent that could be dangerous. And I know the legislature was looking at another issue when they came up with Amendment D, which was making sure that not just interest groups from other states, but there are interest groups from outside the country, which could have an enormous impact if they were to put foreign money into something to advertise for an initiative that would be in the state of Utah. If the Chinese, who have all sorts of money and are interfering in everything, were now to try and put their money behind something, regardless of what it is, those are the types of things that should never happen. And they are happening in other states, and there is a fear that they will continue and increase in the future unless there is some kind of prohibition. So I'm glad the legislature realized that was actually there.
And that's why that foreign source of money was actually put in that Amendment D.
Yeah. So I worry about non-Utah money coming in and making things weird.
Yeah, rather than Utah citizens, because that's an important thing. Citizens have the right to petition government, and that's where this came from, right? But this isn't necessarily, especially look at this Better Boundaries thing. This is not just a group of Utahns that were worried about the boundaries. This was an outside group looking for people in Utah to make their case, right? And I think that's dangerous for us.
And yes. That funding source becomes a significant issue. So I think the Utah legislature was looking forward and being careful in how it looked towards the future of how these initiatives would be run. And a foreign source of money is even more serious than just an out-of-state source of money. Out-of-state source of money bothers me as well, but foreign is just, it should be a no-brainer to go and eliminate foreign sources of funding for PR campaigns to run an initiative. And initiatives are difficult simply because you as a voter are asked to vote yes or no, up or down.
Right.
If you like one part but don't like the other part, you don't have a chance of saying, well, can we amend this in some way? Legislative bodies can, which is some reason why over the last century plus we have allowed legislative bodies to go in and look at these things and make some modifications where they would make a better initiative and better law out of it.
Well, you look at the medical marijuana issue. That was one where there were some tweaks that were agreed upon beforehand in order for certain people to back off of opposition to it. And there's an example of an initiative that actually passed in quite a few counties across the state, rather than just a select group of people that.
Yeah, but the state was good in making those compromises beforehand instead of just doing it. Well, actually, even the Better Boundaries one that they're talking about, they agreed upon changes because the verbiage of the Better Boundaries initiative was basically unconstitutional. So there was an agreement to make those modifications by the legislature. And if you actually do with the ruling the Supreme Court did, you couldn't do that again. It was good that you did it, but the courts have muddied the waters enough right now to make it difficult and fearful of what will be happening in the future.
So what can be done? I mean, of course, this has been struck and off. Well, it's still on the ballot. It just doesn't count, right? But now they're going after Amendment A.
Which, yeah, there's two things there.
Yeah.
First of all, it's enormous that that a court system can say, you can keep it on the ballot, we just won't count the votes for it. That is a really bizarre sentence to give in the first place. But you just mentioned, if the courts do the same thing with Constitutional Amendment A as they did with D, well, the legislature is going to have to start over again, and maybe it's a good thing that they can start over again. But it's the same issue. Should that be a decision made by the courts? Or should you let the balance of power take its role as it was originally designed when the state constitution was written in, admittedly, the progressive era? And let's face it, the progressive era in American history was one where a lot of new ideas were coming out that didn't actually stand the test of time. And if you remember, in the progressive era, the really cool new philosophy of government was communism. So there are a lot of things from that era that we need to take a kind of closer look at if we still really want to continue on with that attempt and that process. But I think the legislature recognized that as they were coming up with Constitutional Amendment D. Plus, you guys in the legislature gave actually some areas in which it made it easier if you have properly funded, not formally funded, really a citizen initiative, easier to actually take place. And maybe it's wise to look at that entire process again of what it takes to actually pass an initiative.
Yeah. I think that's an important thing. In fact, I'm working on a piece of legislation right now to deal with that issue. But now, here's the problem I have with what the court just did. Beyond what the Supreme Court decision was, which I think is a really bad decision, but to actually take it off the ballot. Now we're not even going to have the debate, supposedly, right? And I think that's a dangerous place for us as a legislature to leave things because the talk so far has simply been the legislature's trying to grab more power.
Which is an erroneous argument. And I think it needs to be. That's why I think the legislature needs to start over again, still bring it forward, still keep the discussion going, and let people know that that's not really what the goal is or the goal should be, and take another whack at it so people realize that there has to be some kind of balance here.
So if you had, I mean, this is kind of an opportunity, right? That's why I don't want to drop this thing, because I think the arguments need to be made of why this is dangerous, right? And I don't think the legislature has communicated that so far, because the opposite is a lot easier to communicate. You simply say, this is an example of the legislature seizing power, which I think is erroneous, as we've talked about. But what do we do? I mean, what would you do if you were in charge?
I don't know, to be honest with you. That's why I'm happy I'm not in charge.
Yeah.
That's your problem. But the discussion needs to continue on, because the courts, not only did the courts make this statement about what is the difference between the legislature versus an initiative, when they actually took it off the ballot for D and could take it off for A, they used a technicality that simply hadn't been advertised long enough in a statewide daily paper. and I'm sorry.
And that is the clear language in the law, right?
And they were accurate with that. The problem is, how do you publish anything in a daily paper that we don't have daily papers anymore?
Yeah.
It's now all done online. So the law itself for which they took it off the ballot is one that I think would be impossible to actually do. So maybe that's another discussion that needs to take place on how do you actually advertise and how do you make these things well known.
Well, in the internet era, it seems like you should publish that in a site that everybody would go to for that type of thing. I mean, what we did in terms of publishing it at the at the lieutenant governor's site, I mean, that should be an obvious place of where something like that would be noticed, right?
I would think so. But the language says you have to publish it, which is different in I don't know if it says daily, a statewide newspaper.
Right.
And you don't have anything published in a statewide newspaper anymore. So at least you need to clarify what the intent of that language is. And once again, don't let a judge make the decision of what the words mean. Make sure that the legislative branch
is clear.
They are ones that clarify it.
Yeah, so that I'm sure we'll see something forthcoming on that issue, right?
You got a whole lot of issues that this decision on the Supreme Court has brought up that basically were never part of the discussion before.
Yeah. Well, it's been enlightening talking to you about this, because this is something that's really kind of bothered me in terms of this. If there is any shift in power, this is definitely a power shift between the legislature and the judiciary, right? And that legislative branch includes the power of the people to petition government.
There is a Harvard law professor a long time ago, whose name has escaped me right now, I'm sorry, that when you never get my age, names and nouns go first. But she wrote a book once that called them romantic judges, that a period after Brown versus Board of Education, which was an impeccably good decision, made for really bad arguments, but impeccably correct decision, that at that time in law schools, they came up with a concept that was being taught, that if the judges think the executive or the legislative branch is not doing the right thing, it is imperative that the judicial branch steps forward with a decision that institutes proper policy. Now, I'm sorry, if you really go back to it, the idea that the legislature has the sole power to make the laws, the executive should administer them, and not by an executive order that has the power of creating a new law. And the judges have the power of adjudicating them. It is not the power of a judge to try and recreate law to create a new social pattern of philosophy that they think should take place. That's a romantic activist judge. And we've had lots of those that have happened on the national level, especially through the 60s and the 70s. We have a tendency of the courts now pulling back and seeing their role as much more of looking at the actual verbiage as opposed to saying what it should be. That's what bothers me, that the courts here in Utah have now gone the other direction and taken an activist approach, saying, we think this is what should have been. I don't like the verbiage that you used in this, therefore it should be different. That's an approach that has not been good in the past and has presented lots of problems on the national level. I don't want to see that happening in the state of Utah. But that's what I think the Supreme Court and perhaps the one district judge in Salt Lake actually did with their decisions on D, and maybe with decisions on A coming up.
Yeah, I think we're going to lose the decision on A, but for the same reason.
The same technicality.
Right.
Yeah.
Yeah, which is sad. Well, I appreciate the discussion. I think that it's interesting to have this discussion, and I think this discussion needs to take place more across the state. We can't simply drop this, because the effect of this is, I think, devastating.
It as policy decisions guiding patterns for the future, yes, this is a definite problem that needs to be addressed. And people need to realize it's much more nuanced than simply the legislature is trying to take more power away from the people. That's not what it's about. It is far more significant than that simple stereotypical answer.
Well, I appreciate it. So, Rob Bishop, thanks for coming in. Thanks for the discussion. And one last plug.
That's
The
right.
things I learned in Congress, they never taught in school.
Go on Amazon and do it, because I'm old and need the money.
Very good. Thank you. We'll see you next week.